Lawyers. When did the black sheep flip the whole courtroom? By revealing the final piece no one knew they had? I'm a civil litigation attorney, and this story is about the case that still makes junior associates' jaws drop at the firm. We call it the arrogance clause. And once you hear it, you'll understand why. My client, Dana, was the chief financial officer of a medium-sized tech firm in the Northeast. Brilliant woman. Detail-oriented, calm under pressure, and incredibly ethical. Almost to a fault. She'd been with the company for over 10 years and had worked her way up from an accounting assistant to CFO through grit, brains, and long nights. Then there was Richard Langston. He was the newly hired CEO. Classic narcissist in a power suit. Harvard MBA, loud talker. Insecure at his core, but polished like a diamond. The kind of guy who name-drops billionaires he's never met and ends every sentence with, "It's just common sense." He strutted into the company like it was his birthright, firing half the C-suite and replacing them with yes-men he called visionaries. Within 3 months, HR saw more turnover than they had in 5 years. Dana didn't like him, and he didn't like her. Mostly because she didn't kiss his ring. And narcissists don't forget that. Now, the company had just secured a $40 million investment from a private equity firm. As part of the deal, the investors required all executives to sign a compliance agreement outlining personal responsibility for financial misconduct. This clause would later become our secret weapon, though at the time it looked like boilerplate legalese. I reviewed Dana's version of the document and noticed Richard had added his own clause to everyone's copies, except his own. It read, "Any executive found in breach of fiscal trust or complicit in malfeasance shall be personally liable for 125% of damages, as determined by audit." He called it the arrogance clause. Ironic, really. He'd told the board it would weed out the dead weight, and he made every exec initial it. Dana didn't like it, but signed under protest. She even made a note in her email to the board saying, "I consider this clause retaliatory and redundant given existing compliance protocols." She copied me, thank God. 6 months later, we got the audit report. It was ugly. Richard had approved personal expense reimbursements totaling nearly $1.3 million, all coded under vague innovation costs. Think $18,000 leadership dinners at steakhouses in Monaco, $50,000 for conference travel that was actually a yacht rental in Greece, and a $90,000 equipment lease that turned out to be a custom-built golf simulator for his home. The CFO, Dana, had flagged these repeatedly and been stonewalled by Richard and his cronies. He thought she was bluffing when she raised concerns. He assumed she was too meek, too risk-averse to go over his head. He didn't know she'd already spoken to the compliance team at the investment, and he definitely didn't know that when he demanded she sign his customized version of the agreement, she'd kept every version of every red line he'd ever sent. Once the PE firm's audit came back and they realized Dana had not only refused to authorize any of Richard's reimbursements, but had also reported them discreetly before the audit even started, their tune changed fast. The firm lawyered up. So did we. And for once in my career, I watched a narcissist walk straight into a legal buzzsaw they had built themselves. In Discovery, we found emails where Richard literally wrote, "Dana's a paper pusher. She'll bark, but she won't bite. No one reads the fine print but me, buddy." We do read the fine print. When we subpoenaed his personal assistant, she brought receipts. Literally. She testified under oath that he told her to code stuff however Dana won't notice, and that he called her accounting Barbie in meetings. The court filings were brutal. We filed for civil fraud, breach of fiduciary duty, and damages per his own clause, 125% of the amount misappropriated. Richard countersued for defamation. His own lawyer looked uncomfortable filing the motion. And the PE firm? They joined our side as co-plaintiffs. The case didn't go to trial. It didn't need to, because Richard, in all his smug overconfidence, recorded a podcast episode for a startup interview show where he bragged about how being a leader means pushing the envelope, and creative accounting isn't illegal. It's intelligent. That audio was entered into evidence. The moment the judge heard it, she audibly scoffed. We froze Richard's assets that same week. He called Dana 3 times. Once to threaten, once to beg, and the last time to sob. She didn't answer any of them. She forwarded the voicemails to me. The last one ended with, "I didn't think you'd go through with it." He assumed she was too moral, too soft, too stupid. He assumed wrong. Richard thought he could spin his way out of this. Even after his assets were frozen, he still showed up to board meetings in designer suits, barking about smear campaigns and corporate sabotage. He told the board it was all a misunderstanding, that the auditors didn't understand his entrepreneurial style. He claimed Dana was threatened by his success and bitter because she didn't get to be CEO. The arrogance was suffocating. Meanwhile, the private equity firm wanted blood. They were furious that he'd misused their funds, and even more furious that he did it while acting like he had been the one cleaning house. They joined our side so quickly you'd think we shared an office. Now, here's where it got really nasty. Remember that compliance clause Richard inserted into everyone's contract? Well, he'd smugly exempted himself. His own contract didn't include that 125% liability clause, because, of course, he thought he was above it. But we had Dana's email thread with the board, showing that Richard personally wrote and inserted the clause. We had redlined versions with his initials. We had Slack messages between him and legal counsel where he bragged, "No worries, I didn't include it in mine. They won't notice. They never read this stuff." They noticed. The PE firm argued, and we backed them, that since he unilaterally changed a corporate compliance document for all executives but himself, while explicitly acknowledging his self-exclusion in private messages, that was fraudulent intent. The judge agreed to allow an amended complaint, and we filed an additional count, intentional circumvention of corporate compliance for personal gain. His attorneys started to panic. They tried to settle behind closed doors. Richard refused. He was still convinced he could win. No one's going to take the word of a bitter CFO over a successful CEO, he reportedly told his legal team. Dana didn't need to be bitter. She was patient, because the pièce de résistance hadn't even dropped yet. As part of the discovery process, we requested the source documents for his expense justifications, all those innovation costs. And guess what? Many were forged. One business dinner for $22,000 was actually a birthday party for his girlfriend, complete with a rented mansion, Instagram photos, and tagged vendors. When our forensic accountant cross-checked dates and receipts, he found several Uber charges billed during the conference that went to a strip club in Miami, not to the conference center listed on the reimbursement. And it wasn't just wasteful, it was criminal. We referred parts of the audit to the local district attorney. Charges were opened. Wire fraud, embezzlement, falsifying financial records. At this point, Richard finally started to sweat. He called for an emergency board meeting, said he wanted to resolve the matter quietly and respectfully, brought in a new legal team. He wore a cheaper suit that day. Too little, too late, because while he was trying to make nice with the board, the DA's office had already subpoenaed his travel records, tax returns, and internal correspondence. His assistant, the one he called Accounting Barbie, she flipped completely, handed over a trove of internal memos, handwritten notes, even a burner phone he'd used to communicate with vendors off record. There was one text that sealed it. Make sure the charges go through Dana's line item. She won't fight it. He really thought that she wouldn't fight, that no one. It was this unwavering belief that he was the smartest guy in every room, that everyone else was just filler, that rules didn't apply to him, and no one was paying attention. But Dana was. Every time he rerouted a payment, she flagged it. Every time he manipulated a number, she saved the original. Every time he mocked her for not understanding business, she documented everything. By the time the DA pressed formal charges, Richard's visionary narrative had crumbled into a criminal case. The board terminated his contract for cause. He was escorted out by security, red-faced and shouting, "This is political." He told reporters it was all a misunderstanding, that it was just business. But the truth was, he'd spent years betting on people being too scared, too ignorant, or too polite to push back. Dana wasn't any of those things, and in court, neither were we. By now, Richard had lost his job, his reputation, and his control over the narrative. But what really set this case apart, what made it go from corporate scandal to Reddit famous legend, was what happened after his downfall. See, narcissists don't fade quietly. He didn't retreat. He doubled down. From the moment the charges were filed, Richard launched a social media campaign against Dana and the company. He claimed the investigation was a witch hunt led by a bitter woman, and painted himself as a victim of cancel culture. He even posted a now-deleted LinkedIn manifesto where he accused Dana of orchestrating the entire thing out of jealousy. My personal favorite line? It's easy to crucify brilliance when you don't understand it. The internet did not buy it. Comments flooded in from ex-employees, vendors, and interns who'd witnessed his behavior firsthand. One former assistant posted receipts showing how Richard once tried to expense a $700 bottle of whiskey for morale. Another engineer posted about being fired on Zoom for questioning why the company paid for a $12,000 conference appearance when no one had actually spoken at the event. He tried to sue LinkedIn for allowing defamation. It was thrown out in a week. Meanwhile, Dana kept her head down. She wasn't out for blood. She didn't give interviews. She didn't even celebrate when the board reinstated her as acting CFO with full salary retroactive to her forced leave. She was steady, focused, and so was our legal team. We were preparing for the civil trial, which was now fast-tracked due to the criminal investigation. The court allowed us access to more internal documents, and that's when we hit the goldmine. Richard's personal Google Drive, which had been backed up automatically to his work email. His IT guy never delinked it when he joined. It was like a narcissist's diary. There were spreadsheets labeled quiet bonuses, showing payments to 2 executives we hadn't even flagged, including one who had quietly resigned the week after Dana raised concerns. There were emails where he coached a junior exec on how to filter reimbursements to avoid detection, literally writing, push that under R&D or community development. Dana doesn't check those often. He actually documented how to hide money from her and kept the plan in his own drive. But the worst was a folder titled Back Pockets. It was a collection of dirt he'd gathered on employees, screenshots of Slack messages, half-baked rumors, even photos taken of staff at after-hours events. He kept it all as insurance, his own words in one file. If they ever come for me, I'll burn them all. The judge allowed this into evidence, under strict limitation, of course. And the moment the phrase back pockets came up in the hearing, you could feel the air shift in the courtroom. This wasn't just a guy misusing funds. This was a man who built an entire house of cards on manipulation, threats, and assumption. He assumed Dana was weak. He assumed the board was lazy. He assumed no one would look closer. He assumed that because he understood the system, no one else did. And now, his own files, his own vanity, were the nails in his professional coffin. The press got wind of the Back Pockets folder and had a field day. Headlines called him the CEO, who tried to blackmail his own company. A satirical podcast did a dramatic reading of his leadership principles, which, I kid you not, included the phrase, "There are no rules, only optics." As his image imploded, his legal team jumped ship. One firm cited irreconcilable differences. Another dropped him after he accused the judge of bias in open court. He tried to represent himself at one point, classic narcissist move, and rambled for 40 minutes about visionaries being punished for dreaming bigger. The judge cut him off with a sigh. "Mr. Langston, this isn't a TED Talk. This is a courtroom. Either get counsel or we'll appoint one." By then, he was out of money. His frozen assets were just the beginning. Multiple properties, including the one with the golf simulator, were under lien. The yacht was seized. His bank accounts bled dry from legal fees and PR damage, but even then, he wasn't done scheming. He reached out to Dana directly through a mutual contact, someone in HR who still felt bad for him. He offered her a settlement of silence, as he called it. He'd drop all countersuits and publicly apologize if she agreed to sign an NDA about his personal life. Dana didn't even respond. We sent the offer straight to the judge as evidence of continued coercion. He got hit with a sanction, and the civil trial hadn't even started yet. By the time we reached the pretrial conference, Richard Langston had become infamous. His downfall was no longer a whisper in corporate circles. It was a headline. Tech blogs, legal journals, even a few trashy finance influencers had latched onto the story. They dubbed him CEO Caligula after someone leaked his yacht photos and private party expenses. And yet, despite all of this, he walked into the courtroom like he was still in control. Pressed suit, new haircut, smile so smug it almost made you forget he was facing multiple felony charges. He'd finally hired a new legal team, third one in 4 months. Expensive boutique firm, clearly briefed to keep him on script. But Richard couldn't resist. Within 5 minutes of the first hearing, he interrupted the judge to clarify context. She gave him a look that could strip paint off a wall. "Mr. Langston, if you cannot allow your counsel to speak on your behalf, I will consider removing you from the proceedings." He nodded, then winked at the jury. This was going to be exhausting. Let me tell you about the trial. Because if you've ever wondered what happens when a narcissist truly believes everyone else is the idiot, this was it. Day 1. We walked the jury through the timeline. Dana's emails, the fake reimbursements, the arrogance clause, the texts, the Google Drive. Their eyes widened more with each slide. Then came Richard's turn. He took the stand in his own defense, against his lawyer's advice, of course, said he wanted to correct the narrative. What followed was the most tone-deaf, self-incriminating monologue I've ever witnessed in court. He tried to explain away the yacht as a strategic brainstorming retreat. He called the strip club charges unfortunate vendor overlap. He actually said, out loud under oath, "Accounting is flexible. The numbers tell the story you want, if you know how to write the story." The courtroom fell dead silent. Even his attorney had their face buried in their palm. Dana? She just sat there, emotionless, watching. And then we brought out the assistant. Remember Accounting Barbie? Her real name was Lisa. She was sharp, observant, and absolutely done being underestimated. We walked her through key documents, asked her if Richard ever instructed her to hide expenses. She nodded, calm, factual. He told me to code it under R&D or special innovation, so Dana wouldn't catch it. He said the board wouldn't care if the results looked good. Richard exploded. Right there in front of the jury, he blurted, "Oh, come on, Lisa. You were incompetent. That's why I kept you out of real meetings." Gasps. Audible gasps. Judge banged her gavel. "One more outburst, Mr. Langston, and you will be held in contempt." It was like he couldn't help himself. Like every second he wasn't the center of admiration was unbearable. We moved on to his bonus scheme. Turns out, Richard had quietly funneled bonuses to execs who approved his reimbursements without question. One of them testified reluctantly that he had received an unusual mid-year incentive after signing off on a $48,000 customer acquisition campaign, which was in fact a ski trip. The kicker? That exec had never even seen the itemized receipt. Richard told him not to worry about it. Too much paperwork. This opened the door to show a pattern of manipulation and coercion. We argued that Richard not only committed fraud, but created a culture of complicity through fear, flattery, and financial favoritism. The judge allowed it. And then came the juror moment. Near the end of the second week, during a recess, one juror dropped a comment in the hallway. A reporter overheard and tweeted it. The tweet went viral within minutes. If this guy says, "I'm a visionary" one more time, I might side with the prosecutors just out of spite. That tweet got 100,000 likes before court resumed. Richard's team tried to declare a mistrial. The judge denied it, the juror was dismissed, and a backup was placed. But the damage was done. He had officially become a joke. We rested our case with a final slide showing one of Richard's own Slack messages, sent months earlier when Dana had first flagged a discrepancy. "She's just an accountant. Let her make noise. No one listens to the quiet ones." The courtroom was silent. And then Dana, for the first time during the trial, looked straight at him. She didn't smile. She didn't gloat. She just nodded. Because in the end, it wasn't about revenge. It was about showing that the quiet ones do get heard, especially when narcissists are too arrogant to believe they ever will. The closing arguments were the quietest part of the trial. Not because there wasn't tension, but because by then, everyone knew what was coming. Our final statement was simple. This isn't a story about money. It's about a man who thought he was smarter than the system, smarter than the board, smarter than the law, smarter than you. He believed no one would notice, that people like Dana wouldn't fight back. He was wrong. And today, you get to tell him that. Richard's defense, it was a bizarre mix of self-pity and delusion. His lawyer tried to spin him as a non-traditional thinker, caught in the crossfire of outdated corporate policies. And then, because of course he did, Richard demanded to speak. He stood up, looked at the jury like they were shareholders, and delivered a 5-minute monologue about visionaries being crucified by mediocrity. The judge let him finish. Barely. The jury deliberated for 4 hours. 4. That's all it took. When they returned, they looked exhausted. The foreperson stood, cleared her throat, and read the verdict. Guilty on all civil counts. Liable for $1,625,000 in damages. 125% of the proven misuse, per his own clause. A ripple went through the courtroom. Dana didn't react. Just sat still, arms crossed, calm. But Richard? He blinked. Once. Twice. Then shook his head like someone had whispered the punchline to a joke he didn't understand. This is insane, he muttered. They believed her? His lawyer quietly told him to sit. The judge added a court-mandated reimbursement for legal fees, 6 figures. Then, in a rare move, she addressed him direct. "Mr. Langston, arrogance is not a defense. Manipulation is not leadership. And weaponizing your intelligence to exploit others does not make you smart. It makes you dangerous." That was the end of the civil case. But not the end of Richard. Because karma wasn't finished. See, while the civil suit was winding down, the criminal investigation had kicked into overdrive. The DA's office had been watching the trial closely, and thanks to testimony and evidence presented during the case, the burner phone, the forged invoices, the fake vendor overlap, the grand jury was ready. Just 2 weeks after the verdict, Richard Langston was indicted on 3 counts of wire fraud, 2 counts of falsifying financial records, 1 count of obstruction, and 1 count of witness intimidation for the NDA stunt he tried to pull with Dana. He was arrested at a hotel in New York where he'd been trying to land a consulting gig with a crypto startup, one that ironically wanted to disrupt financial compliance. His mugshot hit Twitter within an hour. The caption that went viral? Remember, the quiet accountant always wins. But what happened next, even I didn't see coming. Because narcissists don't just burn their own bridges. They burn the map. Turns out, while the investigation was ongoing, Richard had secretly set up shell companies using former employees' names and info. He'd been funneling what little cash he had left, selling off art, liquidating crypto, even trying to auction his yacht's interior online, all while insisting in court that he was broke. And the name on one of those LLCs? Dana's. He used her full legal name, registered it in Nevada, filed taxes under it, had checks cut to it. When we found out, I thought Dana might finally break composure. She didn't. She printed out the documentation, highlighted his signature, handed it to the FBI, and went back to her spreadsheet. By the time the feds added identity theft and financial fraud to the stack of charges, Richard's bond had been revoked. He sat in county holding. No suits, no monologues, no yacht. And for the first time, no audience. Because even narcissists eventually run out of mirrors. After Richard was remanded, the silence was deafening. No LinkedIn posts, no press statements, no curated selfies of resilience. For the first time in probably his adult life, Richard Langston had no audience. And for someone like him, that was the harshest punishment of all. But the story didn't stop. Because when narcissists fall, they don't just land hard, they take others with them. After the indictment, a slow wave of second-order consequences began to roll in. Vendors he hadn't paid started filing small claim suits. 2 junior execs who had rubber-stamped his expenses were subpoenaed again. One of them lawyered up and confessed to an informal loyalty bonus system Richard had designed to reward silence. And then someone from his past came forward. Her name was Margaret Linwood. She wasn't connected to the company. She wasn't an investor, a coworker, or an ex. She was his former college professor. And she'd been watching the news. She reached out to Dana's legal team, said she had something we might want to see. What she delivered was jaw-dropping, an academic misconduct report, sealed by the university back in the early 2000s, showing Richard had been investigated for plagiarizing his senior thesis. Not just minor borrowing, either. Whole paragraphs lifted from 3 different sources. He narrowly avoided expulsion by blaming a ghostwriter and filing an appeal that dragged on until graduation. The report included scanned emails where he wrote, "Everyone does it. They're just mad mine is better." Sound familiar? We couldn't use it in the courtroom, of course. It was too old, too remote. But it explained everything. The pattern, the entitlement, the belief that rules don't apply, and that if you win, no one will care how. And speaking of patterns, more disturbing pieces started surfacing. The HR director from his old job, 2 companies back, came forward anonymously through a whistleblower channel. She said he left suddenly after an internal ethics investigation, though the company never disclosed details publicly. She couldn't give us all the files, but confirmed that multiple reimbursements were flagged for misrepresentation. Again, it was the same story. High spending, vague justification, intimidation of anyone who asked questions. At one point, Dana turned to me and said quietly, "How many companies did he get away with this at before he finally picked the wrong accountant?" A damn good question. The court gave us approval to subpoena 2 of Richard's former employers for their internal audit trails. Both responded. One was completely redacted. The other contained a single sentence in the compliance report. "We suspect deliberate manipulation of vendor records, but CEO chose not to pursue further inquiry. Matter closed." That CEO was now one of Richard's character witnesses. We promptly struck him from the list. Meanwhile, Richard's legal team began melting down. 2 of his lawyers filed for withdrawal, citing client non-cooperation and misrepresentation of case facts. He went through 5 lawyers in total. Each one left faster than the last. We heard, through court gossip, that he was trying to draft his own closing arguments from jail. Pages of handwritten notes labeled Defense Script Part 1. Supposedly, it opened with, "You don't jail Michelangelo for painting outside the lines." That got passed around like wildfire in the legal community. But the final blow came from someone completely unexpected. A man named Travis Gallagher, a name none of us recognized, until we learned who he was. Richard's estranged younger brother. He had no social media, no public footprint, but he reached out through Dana's firm, asked for a meeting, and showed up with a quiet fury that matched Dana's patience. He told us things only a sibling could know, like how Richard used to steal from their grandmother's checking account as a teenager, then lie to their parents and say Travis did it. How he faked a recommendation letter for a scholarship. How he told people their dad died when he hadn't, just to get a sympathy extension on a grad school deadline. And how, years ago, when Travis got into a car accident and needed a co-signer for surgery financing, Richard told him, "Sorry, that wouldn't look good on my credit score." He gave us copies of old letters, messages, even a birthday card where Richard had written, "Hope this year you finally learn to play the game like I do." We sat there, stunned. Travis didn't want revenge. He just wanted the court to hear who Richard really was. Not the polished CEO, not the disruptor, but the kid who lied without blinking and climbed every ladder by standing on someone else's neck. So we put Travis on the witness list, not for facts, but for character. Because by now, this wasn't just about fraud or fines or fund misappropriation. It was about hubris, and Richard Langston's assumption that everyone else was too stupid, too scared, or too insignificant to stop him. But they weren't. Not Dana, not Lisa, not the board, the auditors, the jury, or even the brother he'd long forgotten. And soon, it would be time to hear the sentence. It was sentencing day. The courtroom was fuller than I'd ever seen it. Reporters, former employees, rival lawyers, even people who just wanted to see what the end of a narcissist looked like. The judge walked in 10 minutes early, robe stiff, jaw tight. You could tell she wasn't just ready and she was done. Richard was led in wearing a rumpled suit. No more pocket square, no more confident smirk. Just a blank face trying to fake serenity. Dana was already seated, calm, quiet, professional to the last second. The prosecution made their final case, multiple counts of wire fraud, falsified financial documents across jurisdictions, attempted coercion of a witness, use of shell corporations for illegal transactions, identity theft. They concluded with this: Mr. Langston did not just break laws. He engineered systems to believe he couldn't be caught. He created a culture of fear and obedience, disguised as innovation. And worst of all, he never once showed remorse. Not when confronted, not when caught, not even now. Richard's lawyer gave a half-hearted plea for leniency, said his client had suffered public shaming, financial ruin, and professional disgrace, that his fall from grace was punishment enough. Then the judge looked at Richard and paused for a long time. "Mr. Langston, I've presided over hundreds of cases in my career, some involving tragic mistakes, others, crimes of desperation. But yours is different. You didn't just manipulate numbers. You manipulated people. You used their trust as a tool and their doubt as a shield. You believed you were untouchable, not because the system failed, but because you counted on it to fail." She leaned forward slightly. Her voice never rose. "You weren't just arrogant. You were deliberate." And then she read the sentence. 12 years in federal prison, 3 years supervised release, full restitution of $1,625,000 to the company and $140,000 to Dana personally for legal retaliation and damages. Lifetime ban from serving as an officer or director of any public or private company. And, in a move rarely seen, the judge ordered a formal judgment of moral turpitude attached to his record. That last one? It meant no corporate loopholes, no cushy consulting gigs, no board seats under fake names. Richard didn't speak. Not at first, but as they were preparing to remove him, he turned. Not to the judge, not to the prosecution, but to Dana. "You think you won?" he asked quietly. "They'll forget you. They always do." Dana didn't blink. "Good," she replied. "I didn't do this to be remembered." He laughed, just once, bitter, sharp, then turned to be cuffed. That was the last anyone saw of Richard Langston outside of prison walls. But his echo? It lingered. The company rebuilt. The PE firm doubled down on compliance protocols and offered Dana a seat on the board. She declined, said she was ready to move on finally. Lisa got promoted. The interns who had watched the trial unfold got job offers across the industry. The arrogance clause became a cautionary tale in business schools. And Richard? He tried to file a handwritten appeal. He called it a takedown by the mediocre. The court denied it in 4 sentences. I still see Dana once a year. We grab coffee, sometimes talk about the case. But mostly we talk about other things. She's happier now, not vindicated, just free. And every so often, I get a message from some junior lawyer or paralegal somewhere in the country. Is the arrogance clause story real? Did he really say that on the stand? Was it really his own clause that destroyed him? Yes, yes, and yes. Because sometimes when a narcissist builds a system designed to punish everyone but themselves, they forget one thing. Someone will read the fine print, and someone will keep the receipts.